Hi, I'm Lynn Perry Parker. I started LPP Law about 7 years ago after working in national law firms, mid-sized law firms, and small law firms for almost 30 years now. I'm doing this because I am a small business now. And like many small businesses, I love what I do, the law. I love analyzing the law. I like knowing the law. I like applying the law and helping my clients avoid problems or deal with their problems as they resolve. I hate the marketing part of being a small business. So I figured this was the best way that I could actually let you know who I am and how I might be able to help you without having to do the kind of traditional types of marketing. So the next area as you're evolving in your business and what you need to be thinking about is your workers. And I say workers, not employees, because there's a big difference between what we hire as contractors, known as the 1099s, or an employee, a W-2. And this is my primary area of how I spend most of my day, dealing with employment law issues. From, again, the consultative advisory to the I have a problem with my employees right now to the actual litigation that comes with it. And that's everything from your employee of 20 years you found that has been embezzling from you to, you finally got rid of that employee that has been showing up late, doesn't do their job, is, a malcontent. You finally get around to firing them. And of course, what do? They run to the local human rights office and they sue you for discrimination or whatever that may be. I run the gamut. But I could talk all day about employment law because I know so much of it. But I really want to focus on, again, is these kinds of things as a business owner, the fundamentals of what you need to be aware of to successfully run a company, run your employees, and have a rewarding experience and get the benefit of all of your hard work in rather than having to deal with these problems that arise. And some of the most fundamental problems that arise come from a lack of understanding in terms of the employment environment. I call them the misclassification issues. And there's two kinds of misclassification issues. The one is one I alluded to before, of classifying someone as a contractor as opposed to an employee. And why do businesses do that? Lynn, I can't afford to have an actual employee. I can't pay all of those employer-type taxes, the income tax side of the employer's responsibilities, the unemployment, the workers' compensation, the FICA, all of those employer side responsibilities for every employee that they have, and all of the administrative costs that go with that. Not to mention if you're going to have health insurance or 401k plans or all of those types of things. Having employees is extremely expensive. Oh, and I forgot to mention, particularly if you're in the local jurisdictions like Montgomery County that have their own set of laws in addition to Maryland or in addition to the federal laws that apply to employees, like guaranteed paid sick leave, even to the smallest of employers, or the highest minimum wage right now, at least in the area, and what that means for small businesses. So people tell me, I can't afford to have employees. I need to 1099 them. And I tell them, or make them contractors. And I say, the decision to be a contractor or an employee is not a choice. It's by law. And there's certain laws and criteria that will make somebody an employee versus a contractor. And people say, well, so what? Who's going to care? Well, all of those agencies that I just mentioned care, and usually it's not a problem until it's a problem. It's when the employee, the worker, or the one who's been classified as a contractor, you terminate the contract relationship, and then they go to unemployment, and you say, well, when they're a contractor, I don't have to pay unemployment. And based on the law, they really were not contractors, and you're therefore liable for all of those taxes and other employment aspects of being an employee that you didn't pay, not to mention everything else that can go along with that. So it's a serious issue, and not to mention the IRS doesn't like it. All of those agencies that get the benefit of the taxes and the kind of thing are concerned about those issues and those classification issues. Another issue that's along with that, also a misclassification issue, is the designation as an exempt employee that does not have to be paid overtime versus a non-exempt employee. And too many times, many people, and they don't mean to be avoiding the law, but they breach it because they believe that if you pay an employee a salary, that somehow the overtime does not apply. That's not the rule. Whether someone is an exempt employee, it's two prongs. It's the amount of compensation that they are paid, as well as the duties that they perform. Now, presently, the compensation factor is really not that hard to meet, especially in this area, because it's the cost of living. It's only to be an exempt individual from the compensation side is $455 a week, something along those lines, and it's soon to go up. It's the Department of Labor is thinking about meeting that threshold to being $679 a week, which comes out to about $35,000 and some change. But that's just that. Again, that's the compensation piece. That's not so hard to meet. It's the duty-based piece that really limits. Most of employees are non-exempt, meaning you do have to pay them overtime for every time and a half for every hour over 40 hours worked. The only exceptions to those are truly executive, administrative, professional, and what's called highly compensated. And these are the what we call the white collar exceptions. There's others, but for purposes of this, again, these are the types of discussions we can have, and I can explain what the law means by executive, what the law means by administrative, because that's the one that gets violated the most, what the law means by professional, generally architects, lawyers, doctors, ones with absolutely specific professional licenses, and then that highly compensated criteria, what kind of employee actually falls into that, and a lot of other distinctions, but at a base minimum, $100,000 in salary. So as you can see, most employees are going to be non-exempt, requiring you to pay overtime. What I find the biggest problem with this is for government contractors who have made out proposals to the government to get a contract. And I tell them about these laws about overtime. And they say, oh, Lynn, don't worry about it. The government doesn't pay overtime. And I say, I know the government doesn't pay overtime, but you're not government. Just because the government will not pay overtime, they're telling you in your proposals that you better build into having enough employees that don't have to work overtime to get the work done, or that you build it in so that when they do have to work overtime, you are going to pay them for that. And I've seen many contractors really not be able to meet their contractual obligations and even go out of business because they just didn't meet those legal requirements that they had to do as a private business serving the government. I hope you found the information that I discussed on these videos helpful. If you'd like a written outline of the topics that I discussed, I do have an ebook on my website. My website is lpp-law.com. Phone number is 301-444-4513. I love what I do, and I'd love to help your business. Thanks.